the representation out of the way.
Your Honor, Mr. Magistrate, for the record, we would waive the reading and plead not guilty.
Give me one moment. I see a 56A notice filed.
Yes, with no allegations of abuse.
All right. And the clerk will make it a little bit formal. Ms. Solomon, if you would.
Ms. Mullins, on indictment number 2581, CR 00298, count 1 charges manslaughter while operating a motor vehicle. Count 2, motor vehicle homicide felony. Count 3, open and gross lewdness. Count 4, disorderly conduct. At this time, do you waive the complete and formal reading of these indictments?
Yes.
And how do you plead, ma'am? Guilty or not guilty?
Not guilty.
Not guilty. Commonwealth, question of bail.
Yes, the Commonwealth is requesting $100,000 in cash bail with the conditions that if the defendant were to post GPS home confinement with a scram device, substance abuse evaluation and follow-up treatment, that the defendant surrender her passport and that she stays in the Commonwealth of Massachusetts. The basis for this request is that on March 21st of 2025, at approximately 1:20 in the morning, an MIT police cruiser that was operated by an MIT officer was driving southbound on Mass Ave near the intersection of Vassar Street and Cambridge Street. Behind the MIT cruiser was a moped operated by an individual by the name of Daniel O'Neill. Both the MIT cruiser and the moped slowed to a stop at the intersection. Simultaneously, a white Nissan Rogue that was driven by the defendant was traveling in the same direction at a high rate of speed. The defendant struck the moped and rear-ended the MIT cruiser. The moped flipped, causing Mr. O'Neill to be ejected off of the moped and onto the street. Essentially, 2 days later, Mr. O'Neill succumbed to his injuries and died. Additionally, while officers arrived on scene, the defendant was screaming uncontrollably at the officers. She appeared to be unsteady on her feet, and she was stumbling. She also had an odor of alcohol emanating from her breath. The defendant was eventually placed in handcuffs after continuing to be verbally violent towards the officers and refusing to remain still. The defendant also, as indicated in the statement of the case, also elicited other indicia of intoxication, that being after she was read her Miranda rights, she continued to demand to have those rights read to her after refusing to answer questions. She additionally lost her balance off of a bench that she was sitting on. She made other comments to officers that, quote, MIT police is only known for the Boston bombing and hasn't done anything since their officer was killed. She also then singled out a Hispanic officer and stated, quote, I hope that you and your family get deported. The defendant also singled out a black officer and stated she was arresting the defendant to get revenge on white people to incite a race war. Civilians were on scene as the defendant exhibited this behavior and made these statements. While in booking, the defendant repeatedly screamed and threatened officers. She removed her clothing, exposing her vagina and breasts, screaming vulgarities at them. At one point, the defendant yelled at officers, quote, you want my cunt, here it is, end quote, and proceeded to pull her pants and underwear down, exposing her vagina. Officers repeatedly asked the defendant to put her clothes back on, and she refused for a period of time. This happened numerous times throughout booking. Mr. Clerk, due to the nature and circumstances of the offense, the potential penalties that the defendant faces, the fact that the OUI manslaughter indictment does carry a mandatory minimum of 5 years, the fact that the defendant, while she picked up the initial case out of the district court, had an open case involving assault and battery on police officers that she did resolve while this case was pending in the district court, where it appeared that the defendant was under the influence in the body cam of that case, as well as the defendant's out-of-state record, which indicates that she, this past year, was indicted on account of assault and battery on a law enforcement officer. Given all of that information, the Commonwealth is requesting the $100,000 in cash bail with the conditions that were requested. Thank you.
Your Mullins. So her out-of-state record is one indictment for an assault and battery on a police officer?
On a law enforcement officer, as well
Is that resolved, or what's the status of that? I can't pick it out in this triple I.
I did contact the prosecutor's office. There is a prosecutor that we are aware of who's assigned. We're waiting to hear back from him as to an update on that case.
So not disclosed?
It doesn't appear, based off of my read of the triple I, that it's been disposed. It had a disposition date, but then there's no disposition actually entered. And my presumption is that due to the fact that the defendant has been in custody since she picked up these cases in March, or this case in March, that she never appeared in New Jersey to dispose of that case.
All right, and what, her record here is one previous case that resulted in probation, am I right about that?
Yes, and one of the counts, I believe, was time served.
You listed the conditions you're asking for pretty quickly. I got the bail amount, then you said GPS with home confinement.
Yes,
You said a monitoring by screen device, right?
yes, with a substance abuse evaluation and any follow-up treatment, that the defendant surrender her passport.
All right, hold on a second. All right, passport, and then what?
And remain in the Commonwealth of Massachusetts.
So how did you come up with, I'm not saying it's the wrong amount to ask for, but how did you come up, what did you factor in on the $100,000, other than what you've already told me?
Your Honor, initially, the Commonwealth, the defendant, I believe, was held on a $5,000 bail out of the Cambridge District Court. After Mr. O'Neill died and the Commonwealth learned of this information, the Commonwealth brought the case forward. We had requested the $100,000 in cash bail. Judge Frank imposed $65,000 in cash bail in the district court. Given the fact now that the defendant's been indicted, there's a mandatory minimum. We again are requesting that $100,000.
All right, but so tell me the history of that a little bit. So she was arraigned initially, she was held on $5,000 cash, is that right?
I believe it was $5,000. Was it $15,000? Thank you. I apologize. It was $15,000.
But she was unable to post that amount.
Correct.
But understandably so, after events, some facts changed, the death of Mr. O'Neill. You went back in and asked for, the Commonwealth went back in and asked for an increase in bail, is that right?
Yes.
All right, and that's when it went to what amount?
It went to $65,000, and the Commonwealth at that time requested $100,000.
All right. But she's been in custody on the $65,000. She hasn't been able to post any money on this case, right?
Correct.
All right. Do you want to add anything else at this time?
No, thank you.
All right. Mr. Solomon, do you want to be heard?
I do. This is difficult, Your Honor. Ms. Mullins is 33 years old. She's a graduate of Suffolk Law School, and I knew her reasonably well before all of this happened because she was working as a paralegal for the guy in the office next to me. And when she's sober, she's fine. She's a nice person. She's diligent. She did great work. She's intelligent, but she has, as we've learned, a extremely severe alcohol problem, and she doesn't react to it well. It's something she's tried to address in the past and gotten nowhere with, and it led to this. And it led to the two incidents in New Jersey, which were captured on video. So at the district court arraignment, the district court first appearance, I didn't appear for arraignment. There was the television cameras were there. What's his name? Turtle Boy was there, and there was all that to deal with. And that has nothing to do with these two prosecutors who I've found to be capable and very effective and very ethical, but it's the office. It's Middlesex, and they have their own view of things.
Sorry, I missed the last part of that. It's the office.
It's Middlesex, and they have their own view of how they do things, to which they're entitled, of course. I spent a lot of time talking to my client. She understands fully what this is. She understands what this is going to mean to the rest of her life, which doesn't compensate for taking the life of another, but it's there. But as to bail, Judge, I got a death threat on this case in the mail, and her family in New Jersey were harassed unmercifully by the vicious, self-righteous social media people. And the reason I say that is because when a case gets into the media, it takes on a life of its own, and there are various implicit things which have to do with what decisions are made as to the case. She was held on $15,000 initially. I had nothing to do with that. Couldn't make it. It was raised to $65,000. She has not a hope of making it. She had come up here to get a job as a bartender, to study for the bar and try and take it again, because she had been unsuccessful on previous occasions, and she has no assets whatsoever. As you can tell from the probation report, which she gave today, Brangen does count. And the only reason I can see for asking for this bail, and again, nothing to do with these two DAs, to go from 65 to 100 is how the press release is going to look. There's no other legitimate reason for it. 65 is enough to hold, 15 is enough to hold her, but I'd leave that to your discretion. It's our intention to resolve this case. My client, at least talking to me, has taken full responsibility for what happened. She's kind of overcome with remorse every time I visit her, which is pretty frequently, and that doesn't fix things. But it helps us within the context of what we're doing, working here, and how to go forward with it. Mm-hmm. So I'd leave it to your discretion.
All right. I appreciate that, Mr. Solomon. I will say this, although I don't remember hearing anything about this case before coming out here on the bench. I have absorbed all these facts presented by the Commonwealth and you, but as far as any outside influences, as far as I'm concerned.
Mr. Flaherty, I have no worries about you.
Yeah, no, I can understand that. I just thought I'd say that out loud because of what you raised, reasonably so. All right. Sounds like we've got a plan of action in mind, Mr. Solomon, which is not unusual based on my experience with you. As all the parties know, the amount of cash bail is intended to have the defendant back in court. It seems to me that the amount of cash bail that's been in place on each occasion has been sufficient to do that. In fact, she's been in custody. Not only has she been showing up in court, she's been in custody the entire time. I'm right about that? And she's been in custody because of the cash amount of bail that's been posted.
Yes.
Right. Not been posted, been set. So it seems to me that an increase in bail at this time doesn't make sense, although I understand why you asked for it. I'm not saying the request doesn't make sense. I'm just saying my decision now, based on what will ensure her appearing in court, wouldn't seem to result in me increasing the cash amount of bail today, given the fact that the history indicates that she not only will show up in court based on the lower amount, but will not even be at liberty based on the amount that's already been in place. So I think a sufficient amount of bail in this case is $50,000 to ensure that she returns to court. I think that reflects also her history, her criminal history, which is something but minimal based on what we often see here in the Superior Court. And I think that's reflective of the history of this case so far. It also takes into account the very egregious allegations and the very, very serious results of the alleged actions of the defendant and the resulting indictments. With regards to the conditions, I think it does make sense if, at least initially, if she's able to make that amount of bail, that she is subject to GPS monitoring and house arrest. But she's subject to scram testing based on the representations I've heard from both parties, scram testing, and I think it makes sense to do. I was going to say 4, but is 3 more appropriate? All right. So she obviously should be prohibited from, if she ever makes bail, she'll be prohibited from consuming any alcohol at all, any illegal drugs at all. She'll be tested 4 times a day for the presence of alcohol by a scram device. She'll have to surrender her passport if she hasn't done so yet. She'll have to do that with the clerk's office. She'll have to do that before she's released from prison, if ever she's able to raise that $50,000 cash bail. And she is not allowed to leave the state of Massachusetts without a formal motion being filed and a judge ruling on that. The Commonwealth, did I?
Mr. Magistrate, the probation department would like to add the condition of final cover releases in case she's going to get that evaluation, if that's okay.
Right, left that one out.
And then we would like to clarify if we're going to have any windows for medical, legal.
Let me circle back to that. First, did you guys were conferencing? Did you want to add something?
We just wanted to clarify with the court. The Commonwealth requested, at the time that we learned that Mr. O'Neill died, there was a $15,000 bail set. We asked for an increase of $100,000. Judge Frank increased it by $50,000 for a $65,000 bail. At the time, the defendant was not facing the mandatory minimum for the OUI manslaughter, which she's now facing. Would the court be inclined to, if the court's not willing to go with the Commonwealth's recommendation of the $100,000 bail, to at least keep the bail that was set in the district court of the $65,000 now that she's facing a mandatory minimum of 5 years?
Solomon, did you want to be there before I...
At the time the $65,000 bail was set, the possibility of indictment was discussed by all parties, and I informed my client that she was going to get indicted for manslaughter with a 5 mandatory minimum, so she knew.
So, your position is well taken. This is my thought on it. That with regards to the cash bail, the history that I've got before me is that she's unable to post $15,000 or $65,000. And what Mr. Solomon's saying is that she's unable to post $50,000. Seems to me that this bail is outside the reach of her financial capabilities. I'm trying to follow the law that you know about how much bail I can set. And so I understand your request to keep it at $65,000. I understand your request to keep it at, raise it to $100,000. It seems to me that I've got to keep it within a range that reflects the seriousness of the case, but also has at least the possibility that someone will be able to post it. It doesn't seem to me that in this case, there's a possibility that she's going to be able to post it. Mr. Solomon, am I wrong about that? Is she close to being able to post $50,000?
Absolutely not.
So I think that I understand your request, and I understand the chronology of this case, and I understand the steps the government took to that reflected that chronology and the facts as they unfolded. And I accept that, and those are all reasonable. It seems to me, though, at this stage, based on what I understand about the financial capabilities, that $50,000 is the appropriate amount. But I left out one other condition that you asked for that I am going to endorse as well. That is, if she's ever able to make that bail, including the other conditions, she'll have to have a substance abuse evaluation and any follow-up deemed necessary. In these conditions, we do probation ask, as they did just now, and we do allow for time outside of the home for legal and medical. Was there another one? Legal and medical, that's it.
Yes, I didn't ask for, is there any religion?
No. All right, so it would only be for legal and medical, and on both occasions, it'd have to be 48 hours notice to the probation department before should be released from the GPS monitoring from her home.
From confinement, windows for legal and medical. Free from using illegal drugs and alcohol, subject to random screen testing. Pretty much it.
So it's not random screen testing, it's going to be 4 testing. And the surrender of the passport has to be done before she's released from jail, if ever she will post that.
Want it done within 48 hours of release?
No, she has to turn that passport in before she's released.
Okay.
She cannot be released until we have passport.
We do have dates.
All right.
Next week.
Right, so the clerk Petrucci's got to make it official, but I understand that you've discussed dates.
Yeah.
All right. Yes.
Yes. Probation Department has another question, Mr. Magistrate. In terms of the address, where is she going to be residing? Because we just have a New Jersey address.
Undetermined.
Undetermined?
Yeah.
Okay. Thank you.
So obviously, before she's released, if we ever get to that stage, you have to have an address, and the passport has to be turned in before she's released.
Right.
Mr. Magistrate, may the bill be imposed?
Yes.
Ms. Mullins, please stand. Ms. Mullins, it is ordered by the court that you recognize to the Commonwealth of Massachusetts in the amount of $50,000 cash for your appearance before the court. Further, if you make the bail, the following conditions are being imposed. Prior to being released, you are to surrender your passport to the clerk's office. You will be fitted with a GPS with home confinement, windows only for legal and medical, and it must be approved by the probation department 48 hours in advance. You are prohibited from using illegal drugs and alcohol, and you will be subject to scram testing 4 times daily. You are to undergo a substance abuse evaluation with any follow-up treatment deemed necessary and sign all necessary releases with the probation department. And you are to remain in the Commonwealth of Massachusetts. Do you understand? Yes. Ms. Mullins, I must inform you that failure to appear for any scheduled court appearance may result in a $50,000 fine, a 5-year prison sentence, or 2.5 years in the House of Correction. Further, if you commit a new offense while on bail after hearing, your bail in this case may be revoked for a period of up to 90 days. Do you understand and so recognize?
Yes.
The next date will be a scheduling conference, November 12th. That is by email with the clerks in the first session. Your next in-court appearance, Ms. Mullins, will be December 19th at 11 a.m. for a pretrial hearing, and a HABE will issue to Framingham for your appearance.
Pardon me, I think that, email scheduling thing was the 14th,
Is it the,
I thought.
Yes.
14th?
Yes,
So a scheduling conference, November 14th.
Thank you.
Thank you. Custody, Mr. Officer, and the MIT will issue.
Thank you, Mr. Magistrate.
Very much.
Thank you,
Thank you very
Madam
much.
Clerk. I'll see you in a week.
Thank you.
Okay, take care.
Oh my God, I missed I don't even know what was happening that day. I was like, what is happening in the Yeah. I'm so happy. She listens to one out. Okay, what do I need to do?